The United States Constitution is more than just an old document. It is the supreme law of the land. Think of it as the ultimate rulebook for the American government. It lays out the fundamental principles by which the nation is governed, defining the structure and powers of the federal government and guaranteeing the basic rights of its citizens. Crafted in 1787 in Philadelphia, this remarkable text was designed to create a government strong enough to act on a national level but with its power divided and limited to protect the liberties of the people. It established a system of checks and balances, ensuring no single branch could become too dominant. Its importance cannot be overstated. The Constitution is the bedrock upon which American democracy is built. It represents a revolutionary idea for its time, that a government's authority comes directly from the consent of the governed, we the people. This concept of popular sovereignty is the very heart of the document. It provides a stable framework that has allowed the nation to grow, adapt, and face immense challenges over more than 2 centuries. It is a blueprint for freedom, a contract between the American people and their government, outlining what the government can do and, just as importantly, what it cannot do. The creation of the Constitution was a direct response to the failures of the Articles of Confederation, the first governing document of the United States. Under the Articles, the central government was too weak to manage the country's affairs effectively. It could not levy taxes, regulate commerce, or raise a national army without the unanimous consent of the states. The framers, including James Madison, Alexander Hamilton, and George Washington, gathered at the Constitutional Convention to forge a new, more robust system. Their goal was to build a more perfect union, one that could secure liberty and promote the general welfare for generations to come. Understanding the Constitution is essential for every citizen because it defines our rights and responsibilities. It is the source of our most cherished freedoms, such as freedom of speech, religion, and the press. It also outlines the structure of our government, from the halls of Congress to the White House and the Supreme Court. By studying this foundational text, we can better appreciate the intricate design of our republic and our own role within it. The Constitution is not just a historical artifact, it is a living document that continues to shape our daily lives and the ongoing American experiment in self-government. The preamble to the Constitution is its magnificent and memorable introduction. It is a single, powerful sentence that declares the source of the document's authority and outlines its overarching goals. It begins with the 3 most important words in American law, we the people. This phrase signifies a monumental shift in political thought. It asserts that the government does not derive its power from a king, a state, or a divine entity, but from the collective will of the American people themselves. It is a declaration of popular sovereignty, establishing that the citizens of the United States are the ultimate masters of their own destiny and their own government. The preamble then lists 6 specific purposes for which the new government is being established. First, it aims to form a more perfect union, acknowledging the weaknesses of the previous government under the Articles of Confederation and striving for a stronger, more cohesive nation. Second, it seeks to establish justice, creating a fair and impartial system of laws and courts for all. Third, it intends to ensure domestic tranquility, meaning to maintain peace and order within the country's borders. These goals were fresh in the minds of the framers who had witnessed internal unrest and conflict between the states. The fourth goal is to provide for the common defense, empowering the federal government to protect the nation from foreign threats by raising an army and navy. This was a critical function that the weak central government under the Articles could not reliably perform. Fifth, the Constitution is meant to promote the general welfare, which allows the government to undertake actions that benefit all citizens, such as building infrastructure and supporting economic prosperity. This clause provides a broad basis for many of the government's functions today. It reflects the idea that the government should actively work to improve the lives of its people, not merely protect them from harm. Finally, the preamble concludes with the ambition to secure the blessings of liberty to ourselves and our posterity. This phrase encapsulates the ultimate purpose of the Constitution, to protect freedom not just for the founding generation but for all future Americans. It is a promise of enduring liberty, a commitment that the new system of government is designed to safeguard individual rights against government overreach. In essence, the preamble is the mission statement of the United States, a concise and eloquent summary of the aspirations that the framers hope to achieve through the detailed framework that follows in the Articles. Article 1 of the Constitution is the longest and most detailed of all the articles, reflecting the framers' belief that the legislature should be the most powerful and important branch of government. It establishes the legislative branch, known as Congress, and grants it all legislative powers of the federal government. This means that Congress is the only body with the authority to make laws for the entire country. Article 1 divides Congress into two chambers, a system known as bicameralism, the House of Representatives and the Senate. This two-house structure was a compromise designed to balance the interests of states with large populations and those with smaller ones. The House of Representatives is often called the People's House because its members are elected directly by the people every 2 years, making them highly accountable to their constituents. The number of representatives each state gets is based on its population, a principle established to ensure that states with more people have a greater voice in lawmaking. To serve in the House, a person must be at least 25 years old, a U.S. citizen for 7 years, and a resident of the state they represent. The House is given the special power to initiate all bills related to raising revenue, that is, taxes, and also has the sole power of impeachment, which is the ability to formally accuse a federal official of wrongdoing. The Senate, on the other hand, was designed to be a more deliberative and stable body, representing the interests of the states as a whole. Each state, regardless of its size, receives 2 senators, ensuring that smaller states have an equal footing with larger ones in this chamber. Originally, senators were chosen by state legislatures, but the 17th Amendment later changed this to direct election by the people. Senators serve 6-year terms, which are staggered so that only 1/3 of the Senate is up for election every 2 years. This structure helps maintain continuity and experience. To be a senator, one must be at least 30 years old, a citizen for 9 years, and a resident of their state. Article 1, Section 8 is a crucial part of the article, as it enumerates the specific powers of Congress. These include the power to tax, borrow money, regulate interstate and international commerce, coin money, declare war, and raise and support armies and navies. This section also contains the necessary and proper clause, which gives Congress the authority to make any laws that are necessary and proper for carrying out its other listed powers. This clause, also known as the Elastic Clause, has allowed the federal government to adapt and expand its role over time to meet the changing needs of the nation, making Article 1 a dynamic foundation for federal authority. Article 2 of the Constitution establishes the executive branch of the federal government, which is responsible for enforcing the laws created by Congress. It vests the executive power in a single individual, the President of the United States. This was a significant decision by the framers, who debated whether the executive should be a single person or a council. They ultimately chose a single president to ensure decisive action and clear accountability. Article 2 outlines the president's powers, responsibilities, and the process for election and removal from office. It sets the term of office at 4 years and establishes the qualifications for the presidency. To be eligible for the presidency, the Constitution requires that a person be a natural-born citizen, at least 35 years old, and a resident of the United States for 14 years. The article details the original method of electing the president through the Electoral College, a system where electors chosen by each state cast votes for president. This system was a compromise between electing the president by a popular vote and electing the president by a vote in Congress. While complex and sometimes controversial, the Electoral College remains the constitutional process for selecting the nation's chief executive. It underscores the federal nature of the American system, blending state-based and national representation. The powers granted to the president in Article 2 are substantial. The president serves as the commander-in-chief of the armed forces, giving them direct control over the military. They have the power to grant pardons for federal crimes, make treaties with foreign nations, with the advice and consent of the Senate, and appoint ambassadors, federal judges, and other government officials, again, with Senate approval. The president is also required to periodically give Congress information on the state of the Union and recommend legislation they believe is necessary. This duty has evolved into the annual State of the Union Address, a major political event. Article 2 also provides a mechanism for holding the president accountable and removing them from office if necessary. It states that the president, vice president, and other civil officers can be removed from office through impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. The process involves the House of Representatives bringing charges, known as impeachment, and the Senate conducting a trial to determine whether to convict and remove the official. This power of impeachment is a critical check on the executive branch, ensuring that no president can act above the law and betray the public trust without consequence. Article 3 of the Constitution creates the judicial branch of the federal government, which is, the system of courts that interprets the laws. This article is actually quite a bit shorter and less detailed than the articles establishing Congress and the presidency, which kind of reflects the framers' more uncertain vision for the judiciary. It vests the judicial power of the United States in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. This language creates the U.S. Supreme Court as the highest court in the land and gives Congress the flexibility to design the rest of the federal court system, which it did with the Judiciary Act of 1789. The Constitution ensures the independence of the judiciary by granting federal judges life tenure. Article 3 states that judges shall hold their offices during good behavior, which means they can serve until they retire, resign, or are removed through the impeachment process. This provision is designed to insulate judges from political pressure from the other branches of government or from the public, allowing them to make rulings based on the law and facts rather than on popular opinion or political influence. Their compensation is also protected. Congress cannot decrease a judge's salary while they are in office, further securing their independence from legislative control. Article 3 defines the jurisdiction of the federal courts, meaning the types of cases they are allowed to hear. Federal courts have the authority to decide cases involving the Constitution itself, federal laws, and treaties. They also handle disputes between states, cases involving the United States as a party, and certain cases involving citizens of different states, known as diversity jurisdiction. The Supreme Court is given original jurisdiction in a few specific types of cases, such as those involving ambassadors or when a state is a party, meaning it can hear these cases directly. For most cases, however, the Supreme Court has appellate jurisdiction, which means it hears cases on appeal from lower federal or state courts. While not explicitly stated in the text, one of the most important powers of the judicial branch is judicial review. This is the power of the courts to declare that a law passed by Congress or an action taken by the executive is unconstitutional and therefore void. This principle was firmly established by the Supreme Court in the landmark 1803 case of Marbury v. Madison. Judicial review serves as a powerful check on the other two branches, ensuring that they operate within the limits set by the Constitution. It really solidifies the judiciary's role as the ultimate interpreter of the Constitution and guardian of its principles. Articles 4 through 7 of the Constitution provide the essential framework that holds the Union of States together. They address the relationships between the states, the process for admitting new states, the supremacy of federal law, and the method for ratifying the Constitution itself. Article 4 is often called the States Relations Article. It requires states to honor the laws, public records, and court decisions of other states through its full faith and credit clause. This, ensures that a legal judgment or a marriage license issued in one state is recognized in all others, promoting national unity and really facilitating commerce and travel across state lines. Article 4 also includes the Privileges and Immunities Clause, which prevents states from discriminating against citizens of other states. For example, a state cannot impose higher taxes on non-residents or deny them access to its courts. This clause fosters a sense of national citizenship. Additionally, Article 4 outlines the process for admitting new states into the Union and guarantees to every state a Republican form of government. This means the federal government will ensure that each state maintains a representative democracy. It also promises to protect each state against invasion and, upon request, against domestic violence, underscoring the federal commitment to state security. Article 5 describes the formal process for amending the Constitution. The framers, understood that the document would need to be adapted over time, so they created a rigorous but achievable two-step process. An amendment can be proposed either by a two-thirds vote of both houses of Congress, or by a national convention called for by two-thirds of the state legislatures. Once proposed, an amendment must be ratified or approved by three-fourths of the state legislatures or by conventions in three-fourths of the states. This difficult process ensures that changes to the nation's fundamental law are made only with broad, national consensus. Finally, Articles 6 and 7 finalize the structure of the new government. Article 6 contains the Supremacy Clause, which declares that the Constitution, federal laws, and treaties made under its authority are the supreme law of the land. This means that when a state law conflicts with a federal law, the federal law prevails. This article also requires all federal and state officials to take an oath to support the Constitution and, quite famously, forbids any religious test for holding public office. Article 7 outlines the ratification process for the Constitution itself, stating that the approval of 9 of the original 13 states would be sufficient to establish the new government. The first 10 amendments to the Constitution are collectively known as the Bill of Rights. They were ratified in 1791, shortly after the Constitution itself, to address concerns from many states that the original document did not do enough to protect individual freedoms from potential government overreach. These amendments serve as a foundational guarantee of personal liberties and place clear limits on the power of the federal government. The First Amendment is perhaps the most famous, protecting the core freedoms of expression and belief, the freedom of religion, speech, the press, the right to assemble peacefully, and the right to petition the government for a redress of grievances. The next set of amendments focuses on protecting citizens in their persons and property. The Second Amendment protects the right of the people to keep and bear arms, which was linked in the 18th century to the necessity of a well-regulated militia for state security. The Third Amendment, a direct response to British practices during the Revolutionary War, prohibits the government from forcing citizens to quarter soldiers in their homes without their consent. The Fourth Amendment is a cornerstone of privacy rights, protecting individuals from unreasonable searches and seizures, and requiring that government warrants be issued only upon probable cause, supported by oath, and describing the specific place to be searched and persons or things to be seized. The Bill of Rights also provides a robust set of protections for individuals accused of crimes, ensuring due process of law. The Fifth Amendment guarantees several rights, including the right to a grand jury indictment for serious crimes, protection against double jeopardy, being tried twice for the same crime, and the right to not be forced to testify against oneself, the so-called right to remain silent. It also contains the Takings Clause, which requires the government to provide just compensation if it takes private property for public use. The Sixth Amendment ensures the right to a speedy and public trial by an impartial jury, the right to be informed of the charges, to confront witnesses, and to have the assistance of counsel for one's defense. The final amendments in the Bill of Rights address justice and the balance of power. The Seventh Amendment guarantees the right to a jury trial in certain civil cases, while the Eighth Amendment prohibits excessive bail and fines, as well as cruel and unusual punishments. The Ninth Amendment is a broad statement that the enumeration of specific rights in the Constitution does not mean that other unlisted rights are not also protected. Finally, the 10th Amendment reinforces the principle of federalism, stating that any powers not delegated to the federal government by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Beyond the Bill of Rights, 17 additional amendments have been ratified, each reflecting a chapter in the nation's ongoing story of growth and change. These later amendments have addressed critical issues, expanded voting rights, and refined the machinery of government. The first of these, the 11th Amendment, ratified in 1795, clarified the jurisdiction of federal courts, limiting the ability of individuals to sue states. The 12th Amendment, adopted in 1804, revised the presidential election process by creating separate ballots for president and vice president in the Electoral College, a direct response to the problematic election of 1800, which resulted in a tie. These early adjustments, fixed structural problems in the original design. The most transformative set of amendments came after the Civil War. The 13th Amendment, adopted in 1865, formally and permanently abolished slavery throughout the United States. The 14th Amendment, from 1868, is one of the most consequential, granting citizenship to all persons born or naturalized in the U.S., including formerly enslaved people. It also guarantees all citizens equal protection of the laws and due process of law, provisions that have become central to modern civil rights litigation. The 15th Amendment, ratified in 1870, prohibited the denial of the right to vote based on race, color, or previous condition of servitude, though its promise would not be fully realized for another century. The progressive era of the early 20th century brought another wave of significant amendments. The 16th Amendment in 1913 authorized Congress to levy a federal income tax. The 17th Amendment, also in 1913, provided for the direct election of senators by the people, making the Senate more democratically accountable. The 18th Amendment, ratified in 1919, prohibited the manufacture, sale, and transportation of alcoholic beverages, beginning the era of Prohibition. This was later repealed by the 21st Amendment in 1933, which is the only amendment to be ratified by state conventions rather than legislatures, and the only one to repeal a prior amendment. The 19th Amendment in 1920 was a landmark victory for equality, guaranteeing women the right to vote. The remaining amendments have continued to fine-tune the American system of government. The 20th Amendment in 1933 changed the inauguration date for the President and Congress to reduce the lame duck period. The 22nd Amendment, ratified in 1951, limited the President to 2 terms in office. The 23rd, from 1961, granted presidential electors to the District of Columbia. The 24th, in 1964, outlawed poll taxes in federal elections. The 25th, in 1967, clarified the rules of presidential succession and disability. The 26th, in 1971, lowered the voting age to 18. Finally, the 27th Amendment, which was originally proposed way back in 1789 and ratified in 1992, prevents congressional pay raises from taking effect until after the next election. The U.S. Constitution remains profoundly relevant today, more than 2 centuries after its ratification, because it was designed not as a static set of rules, but as a durable and adaptable framework for self-government. Its endurance is a testament to the wisdom of the framers, who understood that they could not foresee all the challenges a future nation would face. They created a document that balanced stability with flexibility. Its core principles, separation of powers, checks and balances, federalism, and the protection of individual liberty, provide a stable foundation, while the amendment process allows it to evolve and meet the demands of an ever-changing society. The Constitution continues to be the central reference point for our most important national conversations. Debates over the scope of federal power, the meaning of free speech in the digital age, the right to privacy, and the promise of equal protection under the law are all, at their core, debates about how to interpret and apply the Constitution's enduring principles to modern circumstances. It serves as a common ground for political discourse, forcing citizens and their leaders to justify their actions and policies in relation to the nation's supreme law. It is really the rulebook that structures our arguments and guides our path forward as a republic. Furthermore, the Constitution's story is one of an ever-expanding definition of "we the people." While the original document had profound flaws, particularly in its acceptance of slavery and its exclusion of women and non-property owners from the political process, its own mechanisms have allowed for its improvement. The amendments have steadily worked to create a more inclusive and just society, extending the blessings of liberty to more and more Americans. This capacity for self-correction is one of its greatest strengths. The Constitution is not just what the framers wrote in 1787, it is the text as it has been amended and interpreted over generations. Ultimately, the Constitution matters today because it empowers and belongs to the people. It is not a document for lawyers and judges alone, but a charter for every citizen. It reminds us that the government's power is derived from our consent and that it exists to serve us, not the other way around. By understanding its framework and its history, we can more effectively participate in our democracy, hold our leaders accountable, and continue the ongoing work of forming a more perfect union. It is a living document because each generation of Americans has the opportunity and the responsibility to engage with it, to debate its meaning, and to strive to live up to its highest ideals.